May 9, 2023 Unit 4.6 Unit 4 Regulations of Licensees 5. A 3-hour course in ethics is required to be taken c. Before a salesperson's first license renewal. 8. Broker Thomas, who was a member of the City Planning Commission, told his friend Broker Jones that an area was to be rezoned from agricultural use to commercial use. Broker Thomas did not receive any consideration for this information. Broker Jones purchased several parcels in the area and made a profit when the zoning was changed. Which broker has placed his license in jeopardy? A. Thomas violated confidentiality of information received in government capacity. A. Thomas has placed his license in jeopardy by revealing confidential information obtained through his position on the City Planning Commission. This constitutes a violation of the duty of confidentiality owed to his clients and could result in disciplinary action by the state licensing authority. Jones, however, did not commit any misconduct in this scenario as he did not receive any confidential information and did not engage in any illegal or unethical behavior. 9. The maximum amount a person can obtain from a licensee after obtaining a judgment against the licensee for a fraudulent act is d. The amount of the judgment. There is a limit as to what the recovery fund will pay. 10. Which activity requires a real estate license? D. Acting as a mortgage loan broker, or licensed by Corporation Commissioner. 11. A $5,000 fee that a broker charged for negotiating a 3-year second trust deed for $20,000 is D. Legal. Limit applies to second trust deeds under $20K. Answer, D. Legal. Charging a fee for negotiating a loan is legal as long as the broker does not charge a usurious interest rate or engage in any fraudulent or illegal activity. The fee charged by the broker in this scenario is not excessive and does not violate any real estate laws. 13. In advertising a mobile home, a broker used no down payment in the ads because he had arranged a separate loan to cover the down payment. The advertising was B. Expressly prohibited by law. Answer, B. Expressly prohibited by law. Using no down payment in advertising a mobile home when the broker has arranged a separate loan to cover the down payment is expressly prohibited by law. The Real Estate Settlement Procedures Act, RESPA, requires brokers to disclose all financing arrangements in advertisements, including the source of the down payment. Therefore, the broker's actions in this scenario are not legal, ethical or proper. 14. In selling mobile homes, a real estate broker may not a. Have an office where 6 model homes are displayed. B. Advertise no down payment if the payment is to be borrowed. C. Fail to withdraw advertising within 48 hours of receipt of notice of non-availability. D. Do any of these. D. Do any of these. Answer, D. Do any of these. A real estate broker selling mobile homes is prohibited from having an office where 6 model homes are displayed, advertising no down payment if the payment is to be borrowed, and failing to withdraw advertising within 48 hours of receipt of notice of non-availability. 15. After collecting an advance rental fee of $75, you are unable to provide your client with a rental that suits her. When she requests a refund, upon expiration of her rental contract, you must return C. $25. Any amount over 50. Answer, C. $25. According to California law, a real estate licensee who collects an advance rental fee must give the tenant a written receipt that states the amount paid in the terms of the agreement. If the licensee is unable to provide a rental that meets the terms of the agreement, they must refund the advance fee within 48 hours of the time the tenant gives notice of non-availability. In this scenario, since the tenant paid an advance rental fee of $75 and did not receive a suitable rental, the licensee must refund $25 to the tenant, $75, $50, the maximum allowable service charge. 16. Which of the following is not required to be included in the notice required under the Bulk Sales Act 100? Sales price and terms. 22. A broker takes listings in an area where property values are going down because the neighborhood is changing, and there is a mass exodus of whites. Which of the following actions by the broker would be a violation of fair housing laws? A. Advertising sell your property fast before you lose equity. B. Offering whites a lower commission rate to sell their property. C. Both of these. Inducing panic selling. Answer, C. Both of these. Advertising sell your property fast before you lose equity is considered as blockbusting, a practice in which a broker or agent tries to persuade homeowners to sell their property by suggesting that the entry of a protected class into a neighborhood will have a negative effect on property values. This practice is a violation of fair housing laws. Offering whites a lower commission rate to sell their property is discriminatory because it treats people differently based on their race, which is prohibited by fair housing laws. All clients should be treated equally, regardless of their race or any other protected characteristic. 23. Which of the following is an example of staring? A. Directing whites away from mixed-race areas. B. Advertising properties in black areas only in newspapers aimed at black readers. C. Both of these. 25. For a broker's violation of the Civil Rights Act of 1968, the courts would not d. Revoke or suspend the broker's license. Commissioner action. Answer: D. Revoke or suspend the broker's license. The Civil Rights Act of 1968 prohibits discrimination in the sale, rental, and financing of housing based on race, color, religion, sex, national origin, familial status, or disability. If a broker violates this act, the courts may issue a restraining order, award actual damages to the victim, and award punitive damages to deter future violations. However, the courts do not have the authority to revoke or suspend the broker's license for this type of violation. Unit 5 Law of Contracts. 7. Albert gave his friend Baker a deed to a property, which Baker recorded. A year later, Albert and Baker had a dispute. Albert demanded the return of the property because Baker had not given any consideration for the property transfer. Assuming there was no consideration, which statement is correct? D. Baker can keep the property, which was a completed gift. A completed gift. Answer: D. Baker can keep the property, which was a completed gift. If Albert gave Baker a deed to the property without any consideration, it is considered a completed gift, and Baker becomes the legal owner of the property. Therefore, Albert cannot demand the return of the property. Even if Albert had a change of mind, he would not be able to revoke the transfer because it was a completed gift. The lack of consideration does not affect the validity of the transfer. 11. Which statement describes how a court will interpret an ambiguous contract? A. Words take precedence over numerals. B. Parole evidence can be admitted to show intent. C. Handwritten takes precedence over typed. D. All of these describe how a court will interpret an ambiguous contract. All of these describe how a court will interpret an ambiguous contract. 15. Liquidated damages on a duplex that the buyer intended to occupy called for the forfeiture of a $10,000 deposit on a $100,000 purchase price. After the buyer's default, the seller must return B. $7,000. Because buyer intended to occupy a 1 to 4 unit property, damages are limited to 3% of purchase price. 19. Which is not a requirement of every valid contract? A. Consideration. B. Meeting of the minds. C. Writing. D. Legal purpose. Answer: C. Writing. C. Writing is not a requirement of every valid contract. Many contracts can be formed orally or through actions and conduct, as long as the other requirements of a valid contract are met, such as offer and acceptance, consideration, and a legal purpose. However, certain types of contracts, such as contracts for the sale of real estate or contracts that cannot be performed within 1 year, may need to be in writing to be enforceable under the statute of frauds. Unit 6 Real estate contracts. 2. A broker brought an offer to an owner. While the broker did not have a listing, the offer provided for a commission. The owner crossed out the provision for a commission above the signature block and signed the acceptance, which is true regarding the broker's rights. D. There was no listing, so no commission need be paid. 4. The effect of a hold harmless clause is that it c. means the owner agrees to indemnify the agent for losses suffered because of the owner's failure to disclose or the owner's incorrect disclosure. The correct answer is C. Means the owner agrees to indemnify the agent for losses suffered because of the owner's failure to disclose or the owner's incorrect disclosure. A hold harmless clause is a contractual provision in which one party agrees not to hold the other party responsible for any liability, damage or loss that may occur during a transaction or other business activity. In real estate, it is often used to protect the agent from claims resulting from the owner's failure to disclose a material fact. 6. After signing an exclusive right to sell listing, an owner refuses to accept an offer that conforms exactly to the terms of the listing. In this case, specific performance can be obtained by A. the broker. B. the offeror. C. either of these. D. Neither of these. D. Neither of these. No contract with buyer and agent's remedy is the commission. Neither the broker nor the offeror can obtain specific performance in this case. Specific performance is a remedy that can be obtained by a party to a contract when the other party breaches the contract by failing to perform a specific duty that was required under the contract. In this case, the owner has not breached the contract by refusing to accept an offer that conforms exactly to the terms of the listing. The exclusive right to sell listing gives the broker the exclusive right to sell the property, but it does not obligate the owner to accept any particular offer. The owner has the right to reject any offer for any reason, as long as the rejection is not based on a discriminatory reason. 9. A broker's promise to use diligence makes a listing a bilateral contract. 11. The exclusive listing that broker Jones had on the Adams farm expired at noon on December 15. At 1 p.m. on December 15, Adams gave broker Riley an exclusive listing on the farm. At 2:30 p.m. on December 15, broker Jones procured a buyer at the price and terms of the listing. Who is legally entitled to the commission? B. Broker Riley, the broker with the listing. 12. Which provision would least likely be found in a real estate purchase contract? A. Safety clause found in a listing. 13. A termination date is required for all contracts below except A. An open listing. B. An exclusive agency listing. C. An exclusive right to sell listing. D. An option. Answer A. An open listing. 19. A listing broker refuses to split a commission with the cooperating broker after agreeing orally to do so. To collect, the cooperating broker would likely C. Start legal action against the other broker. C. Start legal action against the other broker. If the listing broker agreed orally to split the commission with the cooperating broker, and then refused to do so, the cooperating broker may have grounds to pursue legal action against the listing broker. While it is best to have commission agreements in writing, oral agreements can still be legally enforceable under certain circumstances. 24. A contract for the sale of a residence stated as is. Which statement is true relating to this provision? B. It applies to visible conditions only. 25. As is would most likely protect a seller from hidden defects when the sale is B. Of a commercial property.